Police officers are granted the authority to arrest individuals suspected of committing a crime. This power is crucial for maintaining law and order and ensuring the safety of the community. However, this authority must be exercised responsibly and within the boundaries of the law to protect citizens' rights. Police officers do not write laws. If you are upset by a law being enforced on you or someone you know, then you should probably look to the legislators who are writing the laws. Ordinances are generally local city or county laws. In most cases, ordinances are not jailable offenses. Rather, they are fine offenses. State laws have jurisdiction across a given state and are enforceable by state and local law enforcement. Federal laws hold nationwide jurisdiction and are enforceable by local, state, and federal law enforcement. Federal law enforcement officers do not enforce local or state laws. Here are some key points related to the powers of arrest for police officers. Probable cause. Generally, police officers need to have probable cause to believe that a person has committed a crime before making an arrest. Probable cause refers to a reasonable belief, based on facts and circumstances, that a crime has been or is being committed. Warrantless arrests. In many cases, police officers can make arrests without a warrant if they have probable cause to believe a crime has been committed. This is especially true if the crime is ongoing or if there is a risk that the suspect might escape or destroy evidence. Arrest warrants. In some situations, police officers may need to obtain an arrest warrant from a court before making an arrest. This typically requires presenting evidence to a judge to establish probable cause. Types of crimes. Police officers can arrest individuals for both felonies, serious crimes, and misdemeanors, less serious offenses. The threshold for arrest might vary based on the seriousness of the crime. Citizens arrest. In some jurisdictions, private citizens may have limited powers to make a citizen's arrest if they witness a crime. However, these powers are usually subject to specific legal requirements and should be used with caution. Use of force. When making an arrest, police officers are authorized to use reasonable force to subdue a suspect and ensure compliance. The level of force used should be proportionate to the situation and should aim to prevent injury to all parties involved. Miranda rights. After placing a suspect under arrest, police officers are generally required to inform them of their Miranda rights, which include the right to remain silent and the right to an attorney. Failure to provide Miranda warnings might impact the admissibility of statements made by the suspect. Detention and booking. After an arrest, the suspect is taken into police custody, formally booked, and provided with an opportunity to contact legal counsel. They may also be searched and have their personal belongings cataloged. Bail and court appearance. Depending on the jurisdiction and the nature of the crime, a person who has been arrested may be eligible for bail. Bail allows the individual to be released from custody temporarily with the promise to appear in court at a later date. It's important to note that these principles can vary significantly between jurisdictions and can be influenced by local laws, regulations, and court decisions. If you require specific information about the powers of arrest in a particular jurisdiction, it's advisable to consult the relevant local laws or legal experts. Amendment VI. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The Sixth Amendment right to be informed of the nature and cause of the accusation is another protection meant to ensure that the accused receives a fair trial. A speedy, public trial that is heard by an impartial jury is meaningless if a defendant is left in the dark about exactly the crime with which he or she is charged. The police do not have the power to send you to prison. Sentences are handed down by court officials, such as judges and juries. The process of being found guilty in a criminal prosecution for a felony offense involves several key steps in the criminal justice system. Keep in mind that specific procedures can vary based on jurisdiction and the legal system in place, e.g., common law versus civil law, but I'll provide a general overview of the process. Here are the typical steps. Investigation. The process often begins with an investigation by law enforcement agencies, which may involve gathering evidence, interviewing witnesses, collecting physical evidence, and identifying potential suspects. Arrest. If the authorities have probable cause to believe a person has committed a felony offense, they may make an arrest. The individual is taken into custody, read their Miranda rights, and informed of the charges against them. Booking. After the arrest, the suspect is typically booked into police custody. This involves recording personal information, taking photographs and fingerprints, and creating an official record of the arrest. Initial appearance. The arrested individual is brought before a court for an initial appearance, where they are informed of the charges against them. Bail may be set during this hearing, allowing the defendant to be released from custody pending further proceedings. Preliminary hearing or grand jury. In some jurisdictions, there may be a preliminary hearing to determine if there is enough evidence for the case to proceed to trial. Alternatively, A grand jury may review the evidence to decide if there is probable cause to indict the defendant and proceed to trial. Arraignment. The defendant appears in court for an arraignment, during which they enter a plea guilty, not guilty, or no contest. If the plea is not guilty, the case proceeds to trial. If the defendant pleads guilty or no contest, the court may proceed to sentencing. Discovery. Both the prosecution and the defense exchange information and evidence related to the case in a process called discovery. This helps ensure a fair trial by allowing each side to review the evidence. Pretrial motions. Before the trial, both the prosecution and the defense may file pretrial motions, which can address issues such as evidence admissibility, the exclusion of certain witnesses, or the request to dismiss the case. Trial. If the case goes to trial, both sides present their arguments and evidence before a judge or jury. Witnesses may be called to testify, and evidence is presented. The prosecution must prove the defendant's guilt beyond a reasonable doubt. Verdict. After hearing the evidence and arguments, the judge or jury deliberates and reaches a verdict. If the defendant is found guilty, a sentencing hearing is scheduled. Sentencing. If the defendant is convicted, a separate sentencing hearing is held, during which the judge determines the appropriate punishment based on various factors, including the severity of the crime, the defendant's criminal history, and any mitigating or aggravating circumstances. Appeals. The convicted individual may have the right to appeal the verdict or the sentence based on legal grounds, such as errors during the trial or improper legal procedures. In all of these steps, the police have a very small role in the cause of the incident, the ability and requirements for the arrest, the numerous court hearings and schedules, the arraignment of charges, the allowance of evidence, the verdict in the trial, the sentence if found guilty, the appeal process, and the prison assignment or conditions. Yet police officers are almost always seen as the face of the criminal justice system and the cause of its angst no matter the outcome. In reality, the police neither have control of the incident nor the criminal justice outcome. Stop blaming the police for the actions of politicians and lawmakers who create unpopular laws, judges, juries, and lawyers who litigate them, and prison systems that punish them.